Good evening. This is Rahul Reddy live from Houston, Texas. Every Tuesday, we do bring in immigration updates from 5 p.m. Central Time to 6 p.m. Central Time. Along with me is my business partner, Emily. Emily, what do we have today to discuss?
So we want to start off talking about a leaked cable from the Department of State that discusses the potential of revoking visas for Chinese students who are dealing in sensitive technology. We'll talk about, have we seen this happening? What would be the result of such a revocation? What can be done about it? And, we're hearing a lot in the media about ICE raids. They're definitely increasing. We're hearing more and more about that happening. But are employment based visa holders safe? Is there anything you need to do? Is there anything to be aware of? Are there any, work visa holders that have been in these raids? We'll talk about that. And then we want to go over the H4 EAD auto extension rule because I think a lot of people still are confused thinking that it applies in most cases based on the fact that you filed the renewal, because that's how other auto renewals work. But in the H4 EAD context, it is different. There's additional requirements. So we'll talk about that and how it works. And then lastly, we have more information about what's going on with student visas, FM and J visas. The Department of State is putting a hold on those, not allowing new interviews to be set up because they plan on expanding the vetting of those visa applicants, including social media vetting. So we want to talk about how your online presence might impact your visa status, as well as your potential to run into trouble with applying for a visa at the consulate.
When discussing about the visa revocation, though, I want people to understand that if the people are in United States, if by any chance the Trump administration does revoke the visa, please do not run to your home country, though, because you may get some kind of notification from the consulate saying that they are going to inform the Immigration Custom Enforcement, as they're going to inform the Department of Homeland Security, the CBP, that your visa has been revoked. And if you want to self-deport, you can use an application. Please do not use that one. Because when your visa is revoked, that doesn't mean that you are illegal in the United States. You're still in the service system at that point of time. This happened previously in April first week, where we have seen a lot of students getting visa revoked, but there were issues with the civil system for them, and then that was later on reversed by the courts. But for the Chinese students, if and it happens, though, we do not want you guys to panic and leave the country. Wait and look for us and listen to us. We will guide you at that point of time what to do, what not to do. For those people, especially in April, where they got so scared, they thought that ICE is going to come and lift them up, and they're going to be in jail for 3 months. That did happen, and they left the country, and now they are unable to come back into the United States. So even though if the visa is revoked, you are still active, you can still go to school, but however, you cannot travel international travel. That's one condition that is there. Emily, anything on that?
Yeah, I think it's important to understand the difference in the terminology when they say that they're revoking a visa. That is talking specifically about the stamp that's in your passport that was issued by the consulate overseas. And so the visa that is in your passport is what you need when you are entering the country. It's what you show to CBP when you're knocking on the door saying, please admit me into the United States of America. Once you're in the country, you don't need a visa anymore. You can let your visa expire as long as you are maintaining your status and extending and renewing your status or changing your status. All of that is done through USCIS, and your documentation is through your I-94 that you either get online or it's attached to an approval notice that you get from USCIS. So having a valid visa stamp in your passport when you are physically in the United States is really not relevant to anything related to your status. It does not mean that your status is automatically revoked as well. Those are two different issues. So just be very cautious when, people are saying they're revoking student visas. They're just talking about the stamp in your passport. They're not saying they're revoking status. They don't have the power to do that. The Department of State does have the power to revoke a visa for any reason. They have complete authority over that. and they can do it at any time, but they don't have the authority to revoke someone's status. That has to be done by an immigration judge or by a USCIS decision. And in the cases of the prior F1 students that had their SEVIS records terminated, no one had ever received anything from an immigration judge or USCIS telling them that they were out of status and had to leave. So just um, take everything that you, and the other thing with this is the government tends to not give you all the information. When they were revoking and terminating the SEVIS records before, they were telling people that being in this country illegally is a problem and that you should use the CBP home app to self-deport. They weren't telling you that you didn't have to do that. They were just trying to scare people and get them to do it on their own, which a lot of people did. And as Rahul said, now they can't come back because they can't get the new visa. So just take a minute, make sure you understand exactly how it's impacting you before you take any action. What about these ICE raids? Are people, H1B visa holders working at companies, are they being picked up in these ICE raids? Should they be worried?
No, Emily, I haven't seen any of the people reporting at this point of time, those people who are legally staying in the United States. There are some stray cases where some kids were involved, who were on H4 visa, was involved in some drug offenses that were being picked up. But otherwise, I've never heard any of the H1B people getting affected by the ICE raids, though. However, I want people to exercise caution. I want you to have access to the documents like your passport. I mean, we're not recommending at this point of time to carry passports everywhere. And if you do so, sometimes you may lose it, and that's going to be a big problem for you at a later time. So definitely have access to the passport, have access to your H1B approval, I-94, send an email to yourself so that it's easily accessible for you. If you want to, you can make a small copy of it and keep it in your pocket and carry. That's up to you. I don't. If I were you, probably I would not carry the original documents though. I have not been reported except one or two stray instances where there is an acquisition that they were involved in drug offenses. I have not seen ICE picking up any of the people or troubling at this point of time, especially in their raids, the people who are legally present in the country. I have not seen that, Emily.
Yeah, so that's definitely a good sign. I know with hearing all of the things going on in the media that it sounds like it's happening everywhere. But as Raul said, we've not heard of any employment-based visa holder who has been impacted by an ICE raid or picked up or detained or anything like that. So always good to be cautious and be prepared for it, but they're generally not taking any kind of action like that.
And
How
whenever,
about
whenever,
the go ahead.
whenever when there are some odd things that we hear about, where we have heard that, okay, green card guys are getting deported, H4 EAD person working for multiple jobs getting deported, our offices offer free services for them. We want to speak with them. We don't want to listen to somebody else. My friends, that never ends there. Did you speak with that person? Most probably not. Now, even if you have spoken, I have to speak with that person, or Emily have to speak with this person to make a statement here that the person will have been affected. And for that, we do offer, if there is any odd cases that goes on, we do offer free service. And if somebody you have green card holder coming, everything is perfect, and they've been denied entry into the United States, we want to speak with them. We'll give free advice to them. But believe me, that there is always some twist to it, though, that they've been out of country for a long period of time. They may have some criminal record that they did not tell you about it. So there are things twisted, but for normal people, we have not seen. And if at any point of time we are willing to give them free advice, I will like to speak with them. I don't want to listen to you telling that my friend story. I want to speak with your friend. I want to directly have your friend call me or give me the phone number of your friend. I'll call. I will give a free advice to that person.
All right, on the H4 EAD auto extension. So yes, an H4 EAD can be automatically extended based on a pending renewal as long as it's timely filed, but it's not like a C9 GC EAD renewal auto extension or a STEM OPT auto extension where simply by filing the I-765 application and having that new receipt notice, um, together with the old expired EAD card, you get an auto extension. It does not work that way. The H4s have one additional requirement, and that is that they have to have H4 status beyond the date that their current EAD is valid. So if I have an EAD that is expiring on June 30th, and my H4 is expiring on June 30th, and my spouse's H1B is expiring on June 30th, and we've filed extensions for all of them. When June 30th rolls around, you don't get to keep working. The H1B holder does, but the H4 holder does not because the H4 has not yet been extended beyond June 30th. Once the H4 is approved, extending beyond June 30th, in that situation, if for some reason the EAD is not approved at the same time, it's still pending, now you have the auto extension, but you didn't have it until your H4 got extended. So how do you get the extended H4? Well, you can hope that USCIS is going to process it quickly. And once USCIS approves the I-539, that extends your H4. If the EAD is still pending, now you have the auto extension. But most of the time, that is not helpful because they're not approving the H4 quick enough. They're holding it and processing the H4 and H4 EADs later. So the other option would be to exit the US and apply for a new H4 stamp based on your spouse's H1B approval that's already been approved and extended. But obviously, travel is not easy. It's expensive. It takes time to get the visa appointment. It takes money. There's always a risk that you won't be able to get the visa or that they'll cancel appointments or random things happen. So that's not always the best option. And then there's the kind of the margarita switch, as we would call it, or the automatic visa revalidation, where once your spouse's H1B has been approved, if your H4 has not yet expired, but you've got the H4 pending and your EAD is pending, you may be able to take a trip to Canada or Mexico. And when you come back, you show your spouse's H1B extension approval and get the H4 I-94, the CBP I-94 that you get online. They will usually give you the same date that the H1B extension has been approved for. Now you have an H4 extended. Now you qualify for the automatic extension based on your already pending I-765 application. So that's the workaround for now. We may have to go down the road of litigation again for these cases as we're seeing applicants being separated. The H1B gets approved, the H4 and H4 EAD are still pending, or in cases where they're not filed along with the H1B for whatever reason, that these processing times for H4 and H4 EADs are increasing again, like they were during the prior Trump administration. So we'll definitely have to monitor that, but consider the automatic visa revalidation option with travel to Mexico or Canada. But Canada, you generally have to get a visitor visa there. So that might not be as easy to do as Mexico. But that is the workaround for now. All right, social
That's
media vetting for student visas. What do you think that people who are here on F1 MJ visas, they need to be worried about what they're putting on their social media? Like, what if they shared a tweet that was making fun of President Trump? Is that something that they're going to be vetted for and can be denied the visa for?
I don't think so, Emily. I know that some of the liberal media, I am a liberal, I accept that. I'm not a conservative, and but some of the liberal media is really portraying that as if the State Department is going to look into that. If you make fun of President Trump, Republican Party, they were not going to let you in. I don't think so. That is true in any way at all. Absolutely not true. I don't think so. I've never seen it. No, that's a democracy in it. And if you look into it, the State Department head himself, when he, the kind of comments he has made on President Trump, I don't, it's an, ours is not an adult station, so I cannot disclose the information here. So many kinds of comments were being made against each other. The State Department head, Marco Rubio, and against Trump, and Trump against Marco Rubio when they were contesting. So definitely, they didn't took it very hard, and then afterwards everything was fine between them, and now you see them as a Secretary of State. So I don't think so that, but however, if some people have expressed to opinion in favor of any terrorist organization, especially, let's say, for example, if somebody is a fan of Al Qaeda, has been roaming around saying that Al Qaeda kind of thing, and somebody is a fan of Hamas, which is a terrorist organization, and they've been supporting in the social media for that terrorist organization, which was declared as a terrorist organization, then definitely you may expect some problems coming into United States. They may not allow you to come into United States. For most part of the 95% of the people that I know about, the kind of expression, especially in some democratic, especially the biggest democratic country in India, where the people express about the political parties, BJP, Congress, TRS, I don't know, whatever kind of parties they express it. And they do the same thing when they come into United States. I am not expecting any problem for these people who come from the democratic countries where they express their opinion, criticizing the government, praising the government. I don't see that any problem in it, any problem in that. It's only for those people who are been supporting the terrorist organizations. And believe me, there are some people who do those things. I don't see them much in my Facebook friends. Because I maybe sometimes I just cut them off, or they cut me off when I curse them supporting those organizations. So definitely for majority of the people that I know, 95% of the people, that should not be a problem for at all. However, we have to note that because the Trump administration wants to do it, he put a pause on any more new appointments. That definitely is affecting a lot of students. Sometimes I believe the Trump administration uses some lame excuses just to delay the visa stamping assembly. That might be the reason that I'm thinking about, because if he wants to do vetting, why can't he do it? Who is telling to stop that vetting before? Why does he need to pause the visa stamping? Emily?
Yeah, I mean, when we're specifically talking about social media vetting, this the DS-160 visa application has required applicants to enter their social media handles for years. So they've already have the information. So I don't know what they weren't vetting before or why they need to stop interviews to be able to vet now, because they don't have to ask for any additional information. They already have all of that information. And they even already have the extreme vetting form, the DS 5550 or something like that, that they ask you for your 10-year employment history, 10-year address history, and resume, and all of those things. They already have that in place too. So they could simply ask people to fill that out. I don't see that they need to actually stop the visa interview process, stop issuing the visas in order to implement this policy. As you say, I think it's more just about delay and looking for any simple reason to do that as a means to reduce legal immigration into the US as well.
Some of the questions that were being posed to me was that, hey, can I delete my complete social media? It doesn't get deleted, guys. It gets activated. You are supposed to disclose all your social media, so don't do any of that mistake, though. If you have any concerns about that, definitely it's always good to check with a lawyer about it. But in general, if you just delete the entire thing, it doesn't get deleted. Your opinions are still there. So, and then a lot of people will say, I don't have any social media. That's very strange, especially in the new world with all the smartphones. Either you don't have Instagram, I don't know, whatever not. Right now, social media include WhatsApp also at this point of time, expressing opinions on that too. So definitely, I don't see many people having no social media at all. That's probably if you were born in, I don't know, 1950s, before the First World War, I would say. 1920s, if you're born before the First World War, probably you may not have a social media account, but otherwise everybody does have it. You need to disclose that information. If you delete it, it doesn't it doesn't show very good picture of you, though.
All right, shall we go to questions?
Yep.
All right. Nikhil from YouTube says, my L1A 7-year tenure finishes. Can we go back and then come back after 1 year and still use the last I-140 priority date from the previous tenure? Yes, absolutely you can. So by staying outside the US for 1 full year, you reset the clock and can get a fresh 7 years of L1A time, but that has zero impact on your approved I-140 or your priority date. So if you have the approved I-140 and the priority date is not current, as soon as the date is current, you can move forward with consular processing of the green card if you're still outside the US. Or once you're back on L1, then you just simply file the 485 if you're still with that same company.
A question from Ram. He's asking the question that if what is going on with the biometrics people who were being biometrics people who have done the biometrics. Um, for those people who have done the biometrics, we have not seen definitely no denials at this point of time. In fact, our office, some of our lawyers have reported that their people who have been done the biometrics got their I-140s and H1Bs got approved without any problem at this point of time. We will keep on reporting about this every week until we know very clearly what they're doing. But at this point of time, no arrest, no detentions, and no denials because of that. And we have only seen approvals. Now, of course, if there is an other issues other than the biometric issue, let's say ability to pay or salary issues, that's a different issue. You could be denied. But as far as the biometrics is concerned, we have not seen any denials. Now, the cases that we handle normally are like DUI and certain other kinds of minute crimes, not major crimes like drug offenses and all those things. If they do come in, we normally refer to a different set of lawyers that deal with criminal and immigration set. We only deal with very lesser elements of it. And to our knowledge, we never got any denials of the people who have done the biometrics.
Promote says, my mother visited the US from June to November last year. We're planning for her to visit again from June to October this year. Are there any potential issues or is this okay? There's nothing inherently problematic. Whenever she's coming into the US on that same tourist visa, she always needs to be able to convince the officer that the purpose of her entry is in line with the visitor visa. So she's coming to visit relatives, which is one of the reasons that you can get a visitor visa. So that's fine. That the stay in the US will be temporary. So she needs to have a return ticket to leave the US, that she will leave the US at the end of the stay, that she has sufficient funds to support herself while she's in the US so she won't become a public charge. So she either needs to have her own financial means or proof that you'll be supporting her. And then just it's going to be up to the officer when she's coming in. But the fact that she came, left when she was supposed to before, been out for several months and is planning to come back again, I don't see anything particularly wrong with that.
Deepthi is asking this question. She is moving to H4 EAD. Will she lose the priority date? Absolutely not. You can use the priority date. Once the I-140 has been approved and there's no fraud or nothing involved in it, if you move to H4 EAD and later on, 30 years down the line, you want to let's say for example you got the I-140 with Company A and you moved to H4 EAD 30 years down the line. Now you got another offer with another company and they are filing the labor certification. Can they use the old priority date that was approved 30 years ago? Absolutely yes. The same question is coming with Abhinav Mahajan. He's an H1B, he has an I-140 approval. He is transiting to be J1 physician. Once he transits to J1 physician, can he come back later on and use the I-140 approval? Absolutely yes. However, Abhinav, there may be a little bit caution though that I want to say is that J1 requires that you must have an intention to temporarily stay in United States. The fact that you have a I-140 approval may create some problems, especially when you go for stamping outside the country, because you need to disclose that you have an I-140 approval. And the other thing is that I may want you to file a premium process of J1 transfer from H1B so that you can get, and that too within United States, so that you can get the J1 approved here immediately in United States. You don't wait for a long period of time to get the decision though. But yeah, traveling outside the country in a J1 and after the I-140 approval and wanting to get the stamping may be an issue. But if you stay in the country, it's not an issue. Using the priority date, never an issue.
Rafi says, do you see any chance of an H1B second lottery this year? I think there's a slight chance. Obviously, it's hard to predict because we have no idea how many of the selected petitions have been filed so far. We have till June 30th. We definitely in our office see a majority of filings happening in the month of June. There not a lot of people wait till the last minute for some crazy reason. And so it's a little bit hard to predict. I do see some companies not filing for those that were selected, not across the board, but in some cases. So if there are more and more situations like that where the company got the selection and chooses not to file, then we could potentially see a second lottery. So I know it's very much a non-answer, but it's just really difficult to predict. So until they say that there's not going to be a second lottery, there's certainly a chance that there might be.
Priya is asking this question whether they're still approving the 5-year EADs and advanced parole. The answer is simply yes. They are still approving the 5-year EAD and APs for the adjustment of status applications. We have never seen 1-year or 2-year advanced parole approvals in the past many months. Definitely, we have not seen it. Second question is, are they approving them together? That's Sometimes they are not approving. Previously, when we were filing it, most of the times they were not. I mean, in the past 2 years, I would say, 2 years ago, they were not approving most of the time. But right now, we see a little bit more approving together, but still, not all cases are getting approved together. For EAD and AP is not. EAD is getting approval faster, advanced parole is taking longer. But both of those things are getting approval for 5 years.
Travel Science says company filed the H1B extension and then fired the employee, and the employee gets the extension approval during the 60-day grace period. Is the new I-797 approval valid? Well, I mean, it's valid in that it's approved, but if you're terminated, you're not maintaining H1B status. You cannot maintain your H1B status beyond the 60-day grace period. On top of that, if your termination happened before your extension was approved and your I-94 was expiring in less than 60 days, then it's possible that your grace period will be cut short based on the I-94 extension end date. So I don't think getting that extension approved really does anything for you if the termination happened prior to getting that approval.
Akshay is asking the question. I'm working in one field. I want to concurrently work in a different industry. Can some other company file an H1B, concurrently file H1B? That means, let's say he's working for Apple Computer. Now, let's say, for example, he wants to work as a lawyer. He has a law degree or related thing, and he want to work 4 hours or 10 hours a week as a law firm. Can he do so because his H1B with Apple is in software? Absolutely, you can. No problem, none whatsoever at all.
Market Update says, will using an EB5 AP to travel and re-enter impact my H1B status? No, it does not. So for H1B holders, you have the choice of traveling on your valid H1B visa stamp or using the advanced parole. If you use the advanced parole, even though your I-94 is stamped DA, and given for just 1 year, your H1B status is still valid as long as you're working for that H1B employer under the approved terms and conditions of that H1B petition. And you can go by the H1B I-94 and you're still maintaining your H1B status.
Sai Reddy has his question. He got his green card, but there are some problems with his wife's name. So his wife filed an I-90, which is a replacement of the green card, and he went to the USCIS and got the I-551 stamping, that is a green card stamping in the passport, which is assuming it's still valid. He has a question. If he travels outside the country, will this create any problem? Absolutely not. You can travel, no problem with it. You can use the I-5, the stamp that you have in the passport, as long as the stamping is still valid, the date is valid. I do not see any problem in your traveling.
Hemant says, in the current scenario, which is the better option, change of status or consular processing for OPT students selected in the current year's lottery? Definitely change of status. The only people that benefit from consular processing is your employer, because they are not having to pay extra taxes because you are continuing on OPT, but it provides zero benefit to you, because when it becomes time for you to activate that H1B, you may not be with that employer anymore. And so you've just wasted your chance in the H1B lottery. And a consular processing H1B approval without the visa stamp cannot be transferred to another employer. So even if you've got 2 more years on your OPT time, you've got the STEM extension option. We recommend filing a change of status unless you have travel plans that coincide with the time that the application is pending and are not eligible for a change of status, or if you have some sort of status violation that makes you not eligible for a change of status. But otherwise, if you're eligible for it, you should go for the change of status.
I strongly urge everybody, please apply for change of status. Do not apply for consular processing. If you're trying, don't try to save pennies. Life is at stake. If you don't get the H1B, technically you're not counted toward the H1B until your change of status has been approved. So that is a piece of paper that may not have any value. You can eat peanuts in it if you need to, but that's not a valued paper if you did not apply for change of status. I see so many people's life getting ruined because they went for the consular processing. I came from India. I have the background. I have gone through some of the steps in these things. I understand you much better. Please do not file in the consular processing. File for the change of status.
Sampath says, employer A, I have the H1B, H4, and H4 EAD approved on March 20th. With employer B, the H1B is approved, but the H4 is in progress. So I'm assuming this is the transfer situation. If employer A withdraws, is the H4 EAD still valid to work? Yes, it is, because you have a valid H1B with employer B. I'm assuming you're working for employer B at this point. That means your spouse's other approved H4 is still valid. You don't need the pending one. And that means the other approved EAD is still valid. So no problem with that at all, even if the first company withdraws the approved H1B.
Pramod's wife is an F2 visa. She has a plan to visit India. His H1B is pending. She will go for a H4 stamping. She will go for H4 stamping. Um, any issues? We're not seeing good results in the consulate, guys. I know one of the guy was also asking this question. There are some people who are getting the visas. There are. I'm not telling they are not. A majority of the people are getting it. But I would say the percentage of people getting 221Gs are getting denials has increased significantly. One thing I want to tell everybody that this is a secret I'm telling you guys. Okay, listen to me very carefully. That Trump is anti-immigrant. He doesn't like immigrant. Now, if anybody disagrees with me that he is a very favorable immigration guy, I think so that you should go to a doctor.
AR says, are there any updates you can share on change of status to H1B OPT or STEM OPT for students that had their CVRS records terminated? Well, the good thing I can share is that we haven't heard anything bad happening. And usually we're the first to know when things like that are happening because of all of our different social media and conference call and this YouTube channel. And so I have not come across anybody yet that's faced any kind of long-term consequences caused by the SEVIS termination and reactivation that happened in April.
Okay. MIPTP has this question. After submitting I-485J, can I still receive RFE for initial employers I-140 and 485? It's a very tricky question what you're asking. Let's say you filed I-140 and 485 with company A, and you also filed the I-485J along with it, and 2 years down the line, and now you filed this in 2022, and now you're in 2025, and that's 3 years down the line. Can the USCIS ask, hey, are you still working with company A? If so, provide me the 485J supplement. Yes, they can ask. However, if you're working with company B instead of company A, you have no problem, none whatsoever at all, to file a I-485J with company B. You do not need to provide with company A when you're not working with company A. If you're working with company B, you can just take it. I am no longer working with company A. I'm working with company B. Here is I-485J. Not a problem at all.
Lakshman says, my wife is on H1B with an approved I-140. He's applying for her H4 and H4 EAD with his H1B extension and wants to know if her H4 is approved, can she stay on H1B and keep working until she chooses to switch? No. The H4 approval generally is going to take effect on the date it's approved. And so if that happens, the day it's approved, she is on H4 and no longer in H1B. Hopefully the EAD is approved at the same time, and then she can just keep working based on the EAD. But if there's a delay in getting the EAD approved, she has to stop work once the H4 is approved, assuming it's effective on approval. Now, you can request a future start date on the H4 in the I-539 application. So if she does that and the H4 is approved with that future start date, well, then she's still in H1B status up until the time that that H4 actually takes effect. And then one other weird thing that we see, because we file quite a few of these situations where we're filing an H1B extension, and then for the spouse, we're filing a change of status to H4 and an H4 EAD. Sometimes if you file the H1B extension, let's say your H1B is not expiring until November, and so you're filing a change of status to H4 and an EAD, sometimes those will get approved with a November start date because that's when the H1B start date is going to be. And that can be problematic if you were wanting to switch over to H4 and H4 EAD prior to that. So to avoid that situation, when I'm filing these cases, I file the H1B as an extension plus an amendment plus extension so that I can request the H1B start date to be now, which allows the H4 and the H4 EAD start dates to be now as well.
Question that is coming about Scottish decision that's pending in the Supreme Court, which everybody is listening very carefully, whether or not the district courts have authority to grant injunction nationwide. If that turns out to be unfavorable to the immigrant children that are getting born here in United States, is it good to have a child in the blue state as compared to the red state? Now, for the audiences that are here, everybody knows here that the blue state means democratic states, red state means Republican states. Definitely, there could be an advantage for the people who, if the decision goes otherwise, it could be an advantage, could be an advantage. We can't assure that it will be, but it could be an advantage to have a child born in blue state rather than red state.
Ravi says, what happens to the I-94 if we start using the GC EAD? I mean, it's still there, but you're not relying on it anymore. You are now relying on your pending 485. So your 485 receipt notice is what documents your lawful presence in the country going forward, not your I-94. So you can ignore the date that's on your I-94 that was tied to your non-immigrant status.
Question from Venkat Sheshukumar Govardhan. He's from Facebook. Is asking this question that if a person, it's for his friend, not for him. If a person loses the employment at an EB1C 485 application, how long can he stay in United States? I want this gentleman to contact the immigration lawyer immediately, though. There are ways to preserve to get the green card. Staying is not just only important. If I were that person, I want to get the green card. There is self-employment allowed. There are different kinds of things. Things will be allowed where they can. Definitely, I would like to have him to get a higher position job, let's say in Apple or Microsoft, supervising 15 or 20 people. Then of course the things will be very smoother. But if not, there are some ways where you can preserve, including the self-employment. Is self-employment better than working for Microsoft, where 15 people are working? Definitely not. Definitely not. But if you don't have anything, you should try to look into self-employment, also other aspects of it. Now, we have to assume that you will be interviewed by the immigration, what kind of scrutiny that the immigration will do it. It's better to consult an immigration lawyer so that you can get it. I do not want you to leave the country. Believe me, that's not a good option. If I were you, I would not do that.
Nirmal says, I recently went for stamping, got the visa stamped, but on my way over, my I-94 is 12 weeks short of the end date in my visa stamp. So May 2027 instead of August 2027. Is there a way to fix it? Well, number one, good thing for looking now, as soon as you entered and realizing that rather than waiting until May 2027 to figure that out. So anytime you're traveling into the country, as soon as you're here, check your I-94 on that CBP website to verify what end date they gave you. Do it before you even leave the airport. So you did that and you see that there's a mistake. So the first question is it a mistake? CBP does routinely cut short the I-94 when your passport is expiring before your visa stamp. So if your passport's expiring in May, your visa stamp's expiring in August, May technically was the correct date. There's no way to fix it. You would just renew your passport before May and then travel again, then you'll be fine, or file an extension based on the May end date, not the August end date. But if it truly was an error, deferred inspection is the place to get that corrected. So you have to go to the airport where you entered to the deferred inspection that's tied to that airport. Some of them have an email address that you can use to report an I-94 error, and you can do everything over email. That is definitely preferable. Otherwise, you may have to go physically into the CBP office, and they're a lot of times pretty rude and treat you like you're a criminal and you've done all these things wrong and it's all your fault. So if you can avoid that, great. The other way to fix it would be to just travel and come back again and you'll get a new I-94 and hopefully that time they get it correct. Or just go by May 2027 and file the extension early for whatever your visa category is.
Um, CODWW2 has changed from H1 to F1, completed one semester. Now his perm is matured to 1 year, or probably perm and I-140 got approved. Can he transfer to H1B without completing the education? Will it cause any problem? Absolutely, you can change back to F1. The fact that you left the education in between, I have never seen any problem for the people who have changed like that in their, I've never seen any problem in those things.
Sunpath says H4 EAD is approved with employer A, and then the H1B and H4 have already been transferred and approved with employer B. Is the H4 EAD from employer A still valid to work, or do I need to apply again for an H4 EAD with employer B. The H4 EAD remains valid as long as your spouse is maintaining H4 status. Your spouse is maintaining H4 status as long as you're maintaining H1B status with whichever company you happen to be with. There's no requirement that the EAD be tied to a specific H1B or a specific employer or a specific H4. It's valid on its face as long as your spouse is maintaining H4 status, which she is because she got the H4 approved with your transfer and you're working for employer B on the transfer.
Manikanta, his mother, is trying to travel to United States for a 4 months period on a visiting visa. There seems to be some discrepancies in the mother's name on her passport and his passport as mother's, where his mother's name is listed. I do not think it's a problem. As long as your mother is just coming for temporarily staying in United States, that's not a problem at all. We see this kind of things, especially when you are a US citizen, when you are going to file a green card application directly, when you apply for the green card application for your mom. Sometimes they question those things. Why is the name different? We shoot them by getting a DNA of your mother and you, and then saying that you are the child. And sometimes we got to do it. That's an extra $300 or $400 expenditure. We make our client spend it so that we can resolve the problem. Sometimes what happens is that when you spell the things from English, from a different language, regional language to English, though, the spelling changes. For example, Shiva. Is it SHIVA? Is it SIVA? There are different kinds of things. And believe me, when it comes to Muhammad, oh my goodness, Muhammad has 100 different ways of spelling Muhammad. So definitely, it's not a big issue when it's spelled a little bit different there. Nowadays, everything is going with biometrics. I definitely, when your mother is filing any applications, though, I want people to use, have you ever used other names? They should use that column mentioning it, the other names used, so that in future it'll be much better for them to get any immigration benefits. So that, hey, I've already used other names, I mentioned it in the application. That will be much better for them.
CODWW2 says, I recently changed from H1B to F1 and completed one semester. Now
Emily
can I change
Irons.
back? Oh, you already got that one? Changing back
Yeah,
to
no, no, no,
H1B?
yeah, yeah.
Okay. All right. How about can an H4 EAD holder open a company or startup in the USA? Is it legal? Absolutely. H4 EAD holders are authorized to work for anyone, including themselves, so they can absolutely start a company. It can be an LLC, it can be a partnership, it can be a sole proprietorship, it can be an incorporation. Any of those are fine, and they can do any sort of legal activity with that company, no restrictions at all.
Emily, they can flip a burger in McDonald's.
Absolutely.
Can they
Just
be
don't do
Microsoft
anything with
CEO?
marijuana. Yes,
Can
that's
they be
fine. Yep.
Microsoft CEO? Yeah, okay.
Yes, absolutely. Mhm.
Um, 1 second. Are L1A extension stampings problem in India currently? Absolutely, they are. Uh, Believe me, I told the secret. Don't tell to anybody that Trump administration is not in favor of immigrants. They do not like immigrants. They don't like people coming into the United States. They don't like the people of foreign descent coming, staying in the United States. They don't want people. They don't want people of foreign descent working in the United States. Now, you may ask a question: why is it allowing it? Because Congress passed some laws allowing these L1s, H1s, and other things. It's not easy for him. There is a court system that obstructs him if any denials and all those things. Especially when you go outside for stamping, the court system doesn't work because there is very limited jurisdiction for the courts when they deny the visa stampings in the consulate. That's where. While you are here in United States, it's much better. If you recall, though, the students in April of 2025, when their visa got terminated, they ran away. They went to their home countries, and now everything has been restored. Now they cannot come back because their visa stamping is revoked. So definitely, visa stamping is not a good thing right now. if your dad has a, big villa there in India and has a Ferrari car along with, and an Audi car for his lawyer, like Mr. Rahul Reddy, on top of the Ferrari car, yeah, definitely you can go there. I'll get an Audi for you from you. So otherwise, I definitely don't recommend to go for stamping, sir.
Vamsi says, when the priority date becomes current, if I don't apply for the 485, will I still keep getting H1B extensions based on the approved I-140? No, they do cut that off. So once your priority date has been current for one full year, and you have not filed the 485, when you file that next H1B extension, USCIS will ask you why you have not filed the 485. And if you don't have a valid reason for that, they'll deny the H1B extension. So you basically have 1 year from the day that the priority date becomes current to file the 485. Otherwise, your H1B extensions will stop.
Can I change from H1B to B2 and then still be look for jobs while on B2 application? While you're on while on the B2, can you look for job? This is from Abhishek Trivedi. The answer is absolutely yes, you can. USCIS in its website, of course, it was there in the website. It's still there, but not an active website. But you can still look for jobs. Question from Satish Kotulu. Sorry, this is not Satish. Vamshi from YouTube has this question. This is a very interesting question. When the priority date becomes current, and if
Oh,
I
I
don't
just did that
apply,
one.
oh, you did. Oh, sorry.
Yep. Um, Satish says, I lost my job on AOS. The company is not going to revoke the I-140. Should I submit the new 485J to USCIS when I get the new job or wait until USCIS asks for it? You can go either way on it. There's not really a wrong answer there. What we've noticed for people who proactively submit the 485J when they get the job, it does not stop USCIS from sending an RFE asking for it later. So for that reason, we've kind of decided that it doesn't make sense to hurry up and submit it. So we generally wait until we get an RFE asking for it.
Uh, uh, Antanu Ghosh has this question. Can a H4 go for visa stamping with spouse H1B approval when H4 is still pending approval? So let's say, the husband is a H1B, wife is an H4. They both filed H1B and H4 extension. H1 extension got approved. H4 is still pending. Can the wife go to travel to India, go for H4 stamping with the husband's H1B approval, even though the H4 offer is not approved? This question is from Atanu Ghosh from YouTube. Absolutely, they can. Not a problem. Not a problem. H4 does not need to be approved. They can still go. Absolutely not a problem.
Uma Maheshwar says, does the case remains pending status mean that it's all good per the officer's review and just waiting for the visa number? Not necessarily. It doesn't mean that they've actually reviewed the case. It does mean that they think that there's no visa available. So due to retrogression, they're not taking any action on the case. But does it mean they've actually reviewed everything and everything's good? I don't think so. I think you could still get an RFE for a medical. You could still get an RFE for a supplement J. And for any other reason, still could be called in for an interview. So no, they've not necessarily reviewed the file and are just waiting.
I was on H1B for 15 years. Last year, I had to convert to H1B. Now I'm back in H1B. Can I go to any country for visa stamping, or should I only go to home country? They have removed the home country requirement rule. People can go to any country unless there is a unlawful presence where it requires only that you have to go to the home country. In your case, I don't see any unlawful presence. Technically, you can go to any consulate right now to get the stamping. You don't have to go only to the U.S. U.S. consulate in your home country.
PS says my priority date's February 2013. My medical was done in 2022, which means it's not valid now. Can I get the medical done again now before the priority date becomes current, or should I wait for the RFE? Because right now the medical remains valid indefinitely once it is obtained and submitted, you could potentially get the medical done now and submit it through an interfile. Get a second copy of it that's an original and keep it in the sealed envelope in case you still get an RFE asking for it, so you don't have to get it again. But you run the risk of maybe USCIS changes their policy about how long the medical exam becomes valid. In the 20 years that I've been practicing immigration law, they've probably changed that policy 10 times. So we can't guarantee that the current policy is going to always continue. So as long as you know that going in, it might be worth it to get it done and submit it in advance.
Nizar Ali is asking this question. Are there any FDNS visits for the I-485? Are there been any increase? Yes, there are some FDNS visits for the I-485 pending applications. Is there been increase since this administration come in? Yes, the answer is yes. But are we seeing the FDNS visits, a lot of FDNS visits on the 45? The answer is no. We're not seeing it. Are we seeing a lot of FDNS visits for the H1B transfers, H1B extensions, H1B initial filings? The answer is yes. The amount of FDNS visits have gone very significantly. You also need to understand from January 18th of 2025, with regards to the FDNS, particularly for the H1Bs, the regulations have changed. That means if you don't answer their question, they may just outright deny the case. That's definitely is a big problem. It's a must that you have to respond to the FDNS. Otherwise, you will have to just leave the country. So definitely there are some legal avenues available if you don't want to answer, but it's better that you check with an immigration lawyer. We have seen a very many increased H1B FDNS visits for the people who have filed H1Bs with in-house, where there is no job in-house, where fake in-house projects. A lot of those visits are happening right now. And what we want to be very careful is, if you're in a situation where you have to respond to that person, though, do not lie. We have seen employers telling the employees, lie to the USCIS. Don't do that, because they may put a lifetime ban for you to ever coming to United States. And they are going to inquire into it. Just because you say that there is an in-house project, they're not going to believe it. They're going to inquire more details. So please do not lie. If needed, you can stop responding to them. Let them deny the H1B. Let them revoke the H1B. But I do not want you to tell any lies. And when any of the employer tells you to do it, don't do it at all.
Shake says the H4 I-539 status shows Form G28 was rejected because it was improperly filed. However, my company's attorney says there were no issues with the filing. Should we be concerned about this? No, not at all. I have my own case that is the exact same situation. I cannot find anything wrong with this G28. It's filled out the exact same way I fill out every single G28 I've ever filed. I don't know why they rejected it. Does not have any impact on the I-539 process, does not have any impact on the H4 EAD that may have been filed along with it. The only impact is that if for some reason the attorney needs to reach out to USCIS to follow up on your case or intervene in some way, USCIS won't recognize them as the attorney. So the fix for that would be for the attorney to mail in another G28 for that specific I-539 and hope it makes it into the system. But no impact on the
Sims.
actual cases.
Sims wants to have a thank you note for us. Thank you very much, Sim. He was on H1B, got the green card 5 years ago, or more than 5 years ago. Now he took the oath of citizenship last week. Congrats. Wish you best of luck in your future endeavors. Please keep in mind the young immigrants that are coming in. Be sympathetic when you vote. Be mindful when you vote for them. Vote for the elections, because now you're a citizen.
Lakshmikant says, I submitted the G325R online using the USCIS account for my daughter who's turning 14. USCIS has now scheduled the biometrics appointment. I hope this should be all good. Yes, no problems at all. We've not heard of anyone facing any kind of issues at these biometrics appointment. It's just a standard process. It's for your child. They're lawfully in the country. No issues at all.
AAK has a DUI 5 years ago. His wife has an I-140 approval, EB3 skilled. Will he be able to get the green card? We do not see any problems in getting the green card. There may be little hurdles. You have to provide the documentation. Sometimes they may interview you. Out of the people that I have seen, so many of them, I don't want to number them, but it'll be in thousands, that have gone through that have filed for the green card, had no issues in getting the green card. Though, of course, I'm not encouraging that to be done. I'm not telling that that's a good thing, but we have not seen any person's green card getting denied because of that.
Well, I think we're out of time for today. Thanks everyone for joining us. We'll be back again next week with the latest updates and of course answering your questions live. In the meantime, if you have additional questions or you want to speak with us or any of our attorneys here at Reddy Neumann Brown, you can go to rnlawgroup.com and click the button for consultation. There you'll be able to set up a consultation with any of our attorneys, see their schedules, and have a one-on-one 30-minute call with us so that you can get your questions answered.
Thank you very much.